Today we are discussing about cyber law. Cyber law is the law governing cyberspace. Cyberspace is a very wide term and includes computers, networks, software, data storage devices, the internet, websites, and even electronic devices, etc. Generally, it is paper laws in the paperless world. Criminal law identify a crime as being a wrong against society, even if an individual is victimized. Under the law, society is the victim. Cyber law is seen as an essential component of criminal justice system all over the world. The same applies to cyber law of India as well. The law implemented for cyber security largely vary from country to country and their respective jurisdiction. Keeping in view the urgent need to bring urgent amendments to the existing laws to facilitate electronic commerce and with a view to facilitate electronic governance, the uh, the Information Technology Bill was passed by Indian Parliament on May 17, 2000. The Information Technology Act, IT Act, came into effect on 17th October 2000. So here with the technology boom and easy internet access across the country, cybercrime too has become a pretty common occurrence. From hacking into computers to making fraudulent transactions online, there are many ways in which we can become a victim of illegal cyber activities. To regulate such activities that violate the rights of an internet user, the Indian government has the Information Technology Act 2000 in place. There are different sections that empower internet users and attempt to safeguard the cyberspace. For example, section 66 that deal using password of another person. If a person fraudulently uses the password, digital signature, or other unique identification of another person, he or she can face imprisonment up to 3 years or a fine of rupees 1 lakh. The main aim of cyber law was to provide legal recognition for transactions carried out by means of electronic data interchange and other means of electronic communication and storage of information to facilitate electronic filing of documents with the government agencies. The major provisions of the Act are: first one, electronic contracts will be legally valid, and legal recognition of digital signatures. Security procedures of electronic records and digital signatures are mentioned in the Act. And fourth one, appointment of certifying authorities and controller of certifying authorities, including recognition of foreign certifying authorities. And fifth one, various kinds of computer crimes defined and stringent penalties provided under the Act. The senior police official and other officials are authorized to search any public place without a warrant. And the other main provision, that establishment of a cyber regulation appellate tribunal. This tribunal handle appeals made against the final order of the adjudicating officer or the controller. But an appeal against the tribunal order can only be made in the High Court. And Information Technology Amendment Act 2008, the rapid increase in the use of computer and internet has given rise to new forms of crimes. So penal provisions were required to be included in the Information Technology Act 2008. Also to consider the recommendations by the United Nations Commission on International Trade Laws. Okay, that's all. Thank you.